Common law husband, common law wife. What are these concepts? Well, in law, they're pretty much meaningless. It's an urban myth. There's no such thing as a common law spouse. What we do have is the question, what rights do unmarried couples actually have compared to married couples? The short answer here is probably very few, or more accurately, those rights are quite limited. So, common scenario whereby people aren't married and they own a property. If they own a property 50-50, then by and large, that will be the outcome. But you can also get a situation where they may have made different types of contributions during the relationship, but the property itself is registered in the sole name of one of the partners. So in the event of separation, that means by and large that the property will remain theirs. So you can end up in a very unfair situation whereby people could be in a 20-30 year relationship, and at the end of it, one of the partners pretty much retains everything. So what can you do to protect yourself? Well, at the outset, if you're looking to cohabit, it's always sensible to consider a cohabitation agreement. That is a legal document which will set out what really is going to happen. Now, that could be whilst you're living together in terms of who is paying what bills, what contributions are going to be made to the property. But in terms of ownership as well, it might also set out what you actually own together. So if it is a property and if it's 50-50, it's clear. If you're going to hold it in unequal shares, 60-40, 70-30, that's also clear. So these cohabitation agreements are quite good documents. They don't need to be very long, difficult to understand, and with a lot of legal jargon, but they're there really to set out what happens in the event of separation, and sometimes bolstered by what is called a declaration of trust, which ultimately the Land Registry can be informed of that, just again to set out that the title is owned in a certain percentage and that you are as safe and secure as you can be, and you've got your eyes wide open to this. Now, there are situations where, of course, you may have children, and inevitably, if parties separate, there's going to be issues of child maintenance. But compared to married couples, there isn't a right to spousal maintenance. There's also not a right to pensions or the share of any other assets as well. So the two between unmarried and married, the two financial outcomes can be quite stark. So with this, some care and attention is needed, because I've certainly come across situations myself whereby a party might end up living with the person who actually owns the house already, and he or she may have sold their property and put a significant chunk into the new property, whether to reduce the mortgage or sometimes to build an extension which increases the value of the house. Now we go full circle to what I said before, that the risk is that the property is still owned in the owning party's sole name, and if they separate, that owning party is going to take the benefit. Now in those sort of situations, although there can be absent some agreement document, like I said before, a cohabitation agreement, there can be what's called a constructive trust, that party who made the financial contribution has obviously done that with a view to sharing in the equity in that property. But the evidence and the onus is on them to show that that is the case. And that sometimes can be difficult to prove, subject to what those contributions are and how long ago they made the contributions, because sometimes the paperwork isn't always there. So at any important stage of a relationship, whether at the outset cohabitation or at the end, it is very important that you just check your rights and seek some legal advice.